Okay, good evening. Welcome everybody to our legal update webinar, which will be on some very interesting hot topics in the context of the post-Brexit world we live in today, and also the COVID-19 continuing pandemic that is never ending these days. It will look at some of the challenges that we all face as individuals and or companies in this regard. So we have four very esteemed speakers today who are experts in their respective fields. In particular, we have Christoph Ernzen, who's from Allen & Overy, who will speak on employment law matters. He'll be looking at the COVID-19 vaccinations and what can employers do in that regard. Secondly, we will hear from Mark Shaw from Wilgen on banking and finance aspects, the good and the bad. So we'll see what that is. Thirdly, we have a last minute change to our speaker, and we have very kindly Tazia Dumitru has decided to step in and will speak on the corporate law aspects. She's coming from PwC Legal. And last but not least, we have Vincent Wellens from United Utile Avocat in Luxembourg, who will look at data protection aspects, looking at personal data transfers post-Brexit and processing personal data in a COVID-19 context. So I won't take up much more of your time, as I'm sure everyone is anxious to hear from the speakers themselves. Just in terms of format, I would just note that each of our speakers will speak for approximately 10 to 15 minutes, and then we'll have some time for Q&A at the very end. So please do feel free to submit any questions that you may have for the speakers using the button on your screen. And I'll be happy to raise those to the speakers at the end of the webinar. So moving onwards to our first speaker, we have Christoph Ernzen who is a senior associate at Allen & Overy's employment law team. He has more than 10 years of experience in advising employers on a full range of employment law topics. Over the last 12 to 13 months, he has become quite the expert in COVID-19 related employment law matters, and has covered the employment law part of our last webinar in May 2020. So I think you're in good hands with Christoph. So Christoph, I'll let you step in now.
Thank you very much, Darina. So since the COVID-19 program of the Luxembourg government has been deployed, one of the hot topics among employers obviously is the vaccination of their employees. And I will try to give you an overview of the main questions that we see in that respect. The main question obviously is, do employers have the right to impose the vaccination on employees? So can they require employees to be vaccinated before they get back to the office? And there is a clear answer to that question, and that answer is no. But the reasoning behind that negative answer is that Luxembourg, like almost all other European countries, or all other European countries and almost all other countries in the world, have decided not to make their COVID-19 vaccination program mandatory for the entire population. And as long as there is no general vaccination obligation, employers can also not decide that their employees need to be vaccinated, and that position is in line with the case law of the European Court of Human Rights, which has dealt with similar questions in relation to other vaccination programs. It hasn't ruled on the COVID-19 vaccination program, but on other vaccination programs. So the European Court of Human Rights ruled that a mandatory vaccination program will, by definition, interfere with one fundamental right, and that is the right to private life, and that includes the right to physical integrity of each individual. And that right to physical integrity is extremely highly protected by the European Court of Human Rights. And in practice, it means that a mandatory vaccination program will only be compatible with the Human Rights Convention if it is first provided by law, and secondly, necessary in a democratic society. However, under the COVID-19 crisis, all of the European governments decided that it is not necessary in a democratic society, and they therefore have not made it mandatory, so it's not provided by law, and thereby the conditions of the ECHR are not fulfilled. And that brings us back to the position of employers, given that the Luxembourg vaccination program is not mandatory for the entire populations. Employers can also not impose the vaccination on their employees, because the right to physical integrity of their employees overweights the interest of the employer in their vaccination. Given that employers cannot require their employees to get the vaccination, they may be tempted to at least ask the question whether the employees have been vaccinated or have not been vaccinated. And that question actually mainly is a data protection issue, and I will leave that part for Vincent Wellens in the last part of our webinar, but it is also an employment-related topic. Employers may be tempted to ask the question about the vaccination status mainly during the recruitment process, but also during an existing employment relationship. However, asking that question risks to be a discrimination, or at least risks to lead to discrimination claims, because it touches upon the health status of the employees, which is a protected characteristic. And therefore, any candidate or employee who is asked the question about his health status can either not respond at all or even provide a wrong answer. And for existing employees, it's also not possible for employers to take any valid sanction against such employee who refuses to disclose his vaccination status. And just to come back on the discrimination part of that, discrimination actually is a criminal offense. So one has to be careful there, because the sanctions go up to 2 years of imprisonment and fines up to 25,000 euros. These discrimination claims are relatively rare in Luxembourg, but nevertheless, it is a risk that cannot be completely ignored. And then coming to the next question, do employers have the right to sanction employees who do not get the vaccination or who do not reply to the request on their vaccination status? There again, I think my slide disappeared. But there again, the answer is no, because employees who do not take the vaccination or who refuse to respond to the question on their vaccination status, well, they simply make use of their right, given that the public vaccination program is not mandatory. And as a consequence, employers cannot take any valid sanctions against such employees. And if an employer went as far as proceeding to a demotion or a dismissal of an employee on the basis of the fact that they didn't take the vaccination or didn't respond on the question of their vaccination status, then such demotion or dismissal could even be annulled in court, because it can be related to discrimination. If the employee in fact manages to establish facts from which it may be presumed that a discrimination has occurred, then the burden of proof is reversed, and it will then be up to the employer to prove that there was no discrimination, which will be quite hard if one asks questions about the health status of an employee. And if the employer cannot successfully demonstrate that no discrimination occurred, then the demotion or the dismissal or any disciplinary sanction will be null and void. And in case of a dismissal, the employee will have to be reintegrated in their previous position. So what we see is that employers cannot do much in relation to the vaccination of their employees, but nevertheless, what can they do? The main measures that we see in the market, what employers do is encourage or incentivize the employees to get vaccinated. And one measure there is an information campaign to explain the benefits of the vaccination, so as to convince employees that it is in their interest also to get vaccinated. Another measure is to offer paid time off for employees to get the vaccine. There's currently no legal obligation for employers to offer such paid time off, but it obviously is a good incentive so that more and more employees get vaccinated. In some sectors, like for example in the banking sector, paid time off for medical appointments, which includes appointments for vaccinations, is actually foreseen in a collective bargaining agreement. So if you have that, if you are in the banking sector, then you have a right to paid time off for the vaccination. And finally, another measure that we see that employers are thinking about is special bonuses or premiums for employees who get vaccinated, so as to encourage them to do so. However, one has to be cautious with such premiums or bonuses because they may qualify as a discrimination because they result in withholding a benefit to those employees who decide to not get vaccinated, or who, due to a medical condition or religious beliefs, cannot get the vaccination. And it's probably also on the basis of these arguments that already all the companies listed on the German DAX index publicly announced that they will not pay any vaccination bonuses or premiums. Also, such premiums or bonuses are clearly not market practice, at least at this stage, and I'm not aware of any company who would have implemented such measure in Luxembourg. Then that's it for the vaccination part. Another question that came up relatively recently is if employers can require their employees to present a negative COVID-19 test in order as a condition to return to the office. And there again, there is no legal guidance or recommendation by the Luxembourg government, so we have to somehow find an answer by looking at other scenarios. So if we look at employees who actually contracted COVID-19, so who were tested positive, for such employees, the law only requires them to inform the employer of their incapacity to work, but not of the very nature of their sickness. So they don't have to inform the employer that they were COVID positive. That obviously only applies if the employee was in home office. If the employee who later on was tested positive was in the office and had contact with other employees and may have transmitted the virus, then there is an obligation for the employee to also disclose his positive test. But otherwise, there's no obligation. The employee simply needs to inform that he's on sick leave, but not that he contracted COVID-19. And that's also a position that was confirmed by the Luxembourg Data Protection Authority. So if even employees who contracted COVID-19 do not have to inform the employer about that fact, it is reasonable to assume that an employee who shows no sign of COVID-19 also does not need to first of all to get tested and to show a result to the employer. And by way of analogy, the same reasoning also applies to other health tests in the employment relationship. For example, if we look at drug or alcohol tests, the employer cannot systematically require its employees to undergo such drug or alcohol tests. It can only ask these tests if there are clear signs that the employee is under the influence of drugs or alcohol. And even in such cases, a test can only be made with the employee's consent. So tests will always remain voluntary. Moreover, the purpose of such alcohol or drug tests are also to protect the employee himself, to protect the business, but also to protect the colleagues or clients or suppliers who may be on the premises. However, with regard to COVID-19, there are far more effective measures and less intrusive measures than a COVID-19 test to protect the health and safety of the employees, such as teleworking or imposing masks and social distancing. So here, again, the right to the employee's privacy outweighs the employer's right to ask for a test. And given that there's no legal basis to request such a test cannot be imposed. And then just maybe as a conclusion and as a quick reminder, if you were to consider to implement any such health and safety measures, be it in relation with COVID-19 or be it more generally, do not forget that your staff delegation has to be involved. That will be a right for the staff delegation to be informed and consulted if you had less than 150 employees at the time of the last social elections back in March 2019. If at that time you had 150 or more employees, then it will actually be a right of co-decision of the staff delegation. So you will need the staff delegation's consent in order to implement any health and safety measures. And that's it from my part. So I hand back to Darina.
Well, thank you, Christoph. That was very interesting and some very practical analysis there as well. So moving on to the next section, we have Mark Shaw speaking on banking and finance aspects. Mark is a partner at the Luxembourg law firm Belgian, where he heads the London office. He focuses on investment funds, banking and finance. He's both English and Luxembourg law qualified, and has headed the firm's response to various legal and regulatory challenges posed by Brexit. So over to you, Mark.
Hello. Well, thank you for that, and also thank you, Christoph, because I found that first session very interesting. We never really know what the other speakers are going to talk about, so that was the first time I heard a lot of that. So very good. Well, we're on to slightly drier subjects now of banking and finance, and a couple of issues around Brexit and COVID. And I guess to start off, in terms of Brexit, lots of us might have sort of been breathed a sigh of relief on Christmas Eve. And I, for one, I'm rather sad. I was the highlight of my COVID Christmas was the Brexit Free Trade and Cooperation Agreement, known as the TCA, which gave me something to do over the festive period. Now, while we had a trade agreement from the 1st of January 2021, UK financial services firms lost their passporting rights on that date. So that was obviously the huge trade-off and the less publicised greater issue for a lot of people. And with the EU no longer recognising UK financial services regulation or its trading venues as equivalent, UK-based institutions that have not made structural alterations have been impeded in their ability to serve EU clients. Now, it's well publicised since then that Amsterdam overtook London as Europe's largest share trading venue, with London losing on average €8 billion a day in trading from January, with Euronext seeing a 400% volume increase since 2020. And London's volume decreased by more than 50%. And although less pronounced, these trends have been followed in the derivatives markets. It's not all bad news for London, because, of course, now it's outside the EU, it can form partnerships elsewhere. So, for example, it's no longer bound by the EU's ban on trading Swiss stocks, which is a measure that was imposed in 2019 following a trade disagreement between the EU and Switzerland. So although a small start, it does indicate that there is a potential direction of travel for the UK, although this comes with a warning, as we'll see. So it might be, since we've been sort of dominated with COVID chat and brinksmanship on vaccinations, there hasn't been an awful lot in the press over the last 3 months on Brexit. And ordinarily, when I'm talking about Brexit and legal issues, I've avoided speculating on the politics or timelines and try to focus on legal certainties, which typically means planning for a no deal. But because of the radio silence, there seems to have been quite a lot of confusion on where the current status is. So let's take a shot at explaining where we are. Going back to the announcements that were made on Christmas Eve and the press conferences, both sides stated that they were committed to agreeing a memorandum of understanding, an MOU, on regulatory cooperation for financial services by the end of March. Now, Brexit-driven extensions of deadlines are nothing new. We've seen them all along. So it should come as absolutely no surprise, for example, that the EU's ratification of the TCA has already been extended from the end of February to the end of April. Now, if you're as cynical about the end of March deadline for financial services as I am, then you'd be forgiven, and that would either be in terms of a timeline slippage or some sort of scope of agreement. In this case, it looks like we may not have time slippage, but a consensus is forming that the scope is limited. So, for example, if you were basing your firm's structuring decisions on the likelihood of there being an equivalence decision, I think that would be, at this stage, quite fanciful, and I would prepare to be disappointed. Murray McGuinness, the EU Financial Services Commissioner, was on the Andrew Marr show last weekend, ahead of her meeting with Andrew Bailey on Monday. Now, she said that she was very hopeful that the memorandum would be agreed imminently, which is a positive thing, of course. Sadly, it looks like the MOU will simply be an administrative vehicle for dialogue, which basically means we're not really progressed in any substantive way. Creating a forum for talks is the smallest possible step forward. And obviously the frustration here is that these new dialogue arrangements, which are very similar to what Brussels has with the US, will not in themselves settle the sensitive issues around market access. Now, if you're in a UK-based financial services business, you'd be right in thinking that this is utterly absurd, of course, because the UK remains fully MiFID equivalent, and the UK was actually responsible for the vast majority of drafting the body of law. But as Jonathan Hill, the UK's former Financial Services Commissioner to the EU, said in January, Brussels is in no position or has no intention of doing Britain any favours, because given that the strategy is to build up the EU, why on earth would they? So I guess that's the sort of an early part of sort of disappointing news. And what does that mean in practice? Well, we're at a strange stage in the process in terms of sort of firm or activity structuring. At this stage, clearly any first mover advantage is gone. I think it's too early to determine how various firms' no-deal Brexit planning strategies have played out. I think this is one that management consultants are going to be picking through for years to come. As a firm, we still speak to a large number of clients who have taken the wait and see approach. So if that's you, I don't think you should consider yourself an outlier. And there's no one-size-fits-all approach to structuring. Of course, there are various structuring options available, and that could be not just to build, but also to outsource or a combination of both. And we see all of these. So even in this late stage in the process, my personal view hasn't really evolved from where it was, say, 3 years ago, which is that we still can't assume that there'll be any financial services deal or a meaningful deal, and we can't guarantee its scope or timing. But none of these challenges are insurmountable. So that's, I guess, the sort of slightly disappointing position from an EU level. But what about Luxembourg? Well, clearly I'm biased towards Luxembourg, but I do think that Luxembourg maintains a better relationship with London, as it's more symbiotic and less than competitive than of somewhere, say, for example, like Dublin. Luxembourg's also very much more open to business than other EU jurisdictions, as far as it's permitted to be within the EU rules. So, and this is the good news part, also on Christmas Eve, when the TCA came out of the European Commission, the CSSF wasted no time in extending its financial services equivalence determination to FCA regulated firms by adding the UK to its list of third countries whose regulated firms can provide investment services to per se professional clients and eligible counterparties for the purposes of MiFID. Now, this is not EU-wide MiFID equivalence. It's not a backdoor into Europe. The EU-wide equivalence would have to be granted centrally by the European Commission, and that's the part that we're waiting for and hope to get, but assume won't. These Luxembourg provisions are enacted under the national third country regime and apply to services provided on a cross-border basis to clients only in Luxembourg. So there's no onward passporting. So if you want to benefit from this right to provide services without establishing a branch, you need to be supervised by a level of supervision that the CSSF deems equivalent under the law of 5th of April 93 on financial sector. But the FCA regulation is considered satisfactory for these purposes. Practically speaking, and this is an important point because I think a lot of firms are missing this, the CSSF has a form that you need to complete and file with them. It's very simple, but you need to complete this form if you wish to avail yourself of these measures. And you should also notify when you engage with Luxembourg clients that you are relying on an exemption from local regulation and providing the services on a cross-border basis. So the speed at which the CSSF published these measures and pushed the button on them, shows its commitment to the close relationship for financial services between Luxembourg and the UK. All very positive. Mindful of the time, so a quick word on the funds side of things. I don't have much time to dig into it, but as you probably know, Luxembourg funds or fund management entities can delegate to UK regulated portfolio managers, absolutely fine. But also UK funds can continue to be distributed into Luxembourg, including to retail investors. Now, this is notwithstanding the fact that, for example, for EU purposes, a UK UCITS is now classed as a non-EU AIF. The key stumbling block and the key thing that you need to be aware of here is that in each given case, you need to be very careful that you're applying with the applicable notification or denotification requirements. Now, the CSSF website guidance is very clear on this. It's very useful. If you want to Google anything, the relevant press release was CSSF press release 20/26, which will point you in the right direction. And yes, that's the key thing to be mindful of. So that was financial services. On COVID, there is a lot less for me to say on COVID and financial markets, thankfully, because the vast majority of regulatory measures that we've seen were short term. So just under a year ago, we saw various delays from ESMA on the implementation of regulations, guidance on cybersecurity for remote working, regulatory reliefs on call recording, requirements for MiFID and home working, and short selling disclosure threshold changes. The short selling disclosure threshold changes were the last of these measures to fall away. They fell off on the 19th of March this year. So we're now back to a 0.2% disclosure threshold. I think the key thing to note on the COVID regulatory measures is that we're in a very strange time from a markets perspective. And the stimulus measures that we've seen have created a risk of a bubble in the US, which has hallmarks of both the 1929 and 2000 markets. And if things go sour, it'll happen very quickly. ESMA is very aware of the decoupling of financial market performance and underlying economic activity, and the question of the sustainability of the market rebound. ESMA itself publishes a quarterly risk assessment. So what I would say is watch this space, and it's very good process to review these. Or look on LinkedIn, because I usually publish something on it. ESMA's current position is that it sees a prolonged period of risk to investors of market corrections and a very high risk across the whole of its remit. So in terms of watch this space, I think just as we saw interventions at a national and ESMA level this time a year ago, it's possible that this could happen again if ESMA feels that it needs to use its powers to ensure an orderly functioning of the markets to support investor protection and stability. So that's basically it from me. So thank you for your patience.
Thank you, Mark. That was great. A lot of information there in a short time frame. So thank you very much for that. Next, we're going to move on to the corporate law aspects, which will be dealt with by Nastasia Dumitru. Nastasia is a senior associate in the corporate law team of PwC Legal. She has 10 years of international experience, with her primary area of expertise being in corporate law and M&A, mergers and acquisitions. So with a particular focus on M&A, transactions, spin-offs and restructuring processes. She also advises clients on a wide range of day-to-day corporate matters and drafting and negotiating contracts. So without further ado, I'll pass to Nastasia.
Hi everyone, and it's nice to be with you. Unfortunately, virtually for the moment due to the COVID restrictions. I'm going to try right now to share my screen with you. So together we will discuss together, and we will see together all the impact on corporate governance and all corporate law related matters from a Brexit and COVID perspective. Apart from the COVID-19 situation, which is of course affecting us all, another point of interesting discussion and a very important point on our agenda is obviously Brexit. From a COVID-19 perspective, the good news from a Luxembourg law perspective is that basically the legislature decided to extend all the measures that were imposed during the lockdown by the first regulation dated 20th of March 2020 until 30th of June 2021. So in a nutshell, the ability to hold the GMSs without physical attendance and to take decisions of any other corporate bodies remotely or by circular resolutions will remain applicable. This means that these meetings could be kept remotely using electronic vote, using video calls or audio conferences, or also via a POA granted to an intermediary. Another point of attention, which is maintained by the legislator, is the suspension of the deadline of 1 month, which was provided previously for the filing of an insolvency request, which is also suspended until 30th of June 2021. From a Brexit perspective, things are not that clear as for the COVID-19 situation, as the TCA, unfortunately, does not deal with the corporate law in any significant way. We have good signs under the TCA, meaning that there are principles which allow us to hope that there will be good cooperation between the UK and the EU, such as the non-discrimination provisions and the best endeavours commitment. However, we shall see on a case-by-case basis how corporate law aspects will be treated between Luxembourg and Luxembourg notably, but any other EU members and the UK. From a UK corporate law perspective, the majority of English company law, it's not derived from the EU law. There are certain aspects which govern in general the incorporation and the operation of UK companies. And some of them are also comprised embedded EU directives or EU laws for matters such as shareholder rights, disclosure of information, accounts filling. So there might be the case where under the Companies Act 2006, there are already EU principles which were already translated in the national legislation. And from this perspective, we would have a level playing field between a EU member and the a UK company. So, but in any case, this any similar situation like that should be discussed on a case-by-case basis. The most significant EU provisions that apply to UK companies are the ones which are related to capital markets. Basically, the Withdrawal Act, which was signed in 2018, has converted the directly applicable EU laws into UK law. And from this perspective, we expect that the same level of uniformity and symmetry will apply and will be maintained by the UK legislator going forward. From the perspective of incorporation of companies, unfortunately, as of 1st of January this year, the UK lost the benefit of using the freedom of establishment, one of the 4 fundamental freedom principles of the EU. So from this perspective, the UK incorporate companies will be regarded as third country companies from a EU law perspective, with potential side effects on the recognition of the type of company and on the shareholder liability impact. So from now on, basically, the UK incorporated companies will be recognized in accordance with the rules of private international law applicable in each of the EU member states. The drawback of this and the potential side effects will be the fact that the legal personality of a UK company may no longer be recognized automatically. So it will be again assessed on a case-by-case basis. From a Luxembourg perspective, since we have a real seat approach, which means that the national law applies to third country companies where the real seat or the main center of activities is located, this means that basically a UK company might be deemed to have its real seat in Luxembourg or in any other EU member state that embraces the real seat approach. However, what we need to check from this perspective is if that company is recognized by the national law. Because, for instance, in Luxembourg, we may have formalities which need to be passed in front of a public notary or any other additional formalities to validly incorporate the company. So this would need to be assessed if the real seat approach will enable the recognition of a UK company as being actually a Luxembourg company. The cross-border relocation of the place of management of the companies between member states, which was initially possible, now it's still permitted to the extent it is allowed by the international private law system in each of the jurisdictions. Luxembourg, in this respect, offers this possibility. However, it needs to be checked again on a case-by-case basis if this would be available in all other legal systems. Another loss from a UK perspective would be the fact that all the European company forms which were registered in UK will lose their status, so they will no longer be deemed as European companies, and they will need to be converted into domestic UK company forms and thus later on recognized as such by the other EU member states. From a cross-border mergers perspective, as of 1st of January 2021, the EU cross-border mergers regime is no longer available to UK companies. All the mergers that were initiated under this regime had to be finalized before the end of the year. Basically, from now on, we have to see how the situation will be further tackled. From a Luxembourg law perspective, the good news is that cross-border mergers with a company coming from a third country are permitted to take place, provided that the same is permitted under the legislation of the jurisdiction of the other companies involved. National rules will remain to be applied for mergers involving third countries. So we are waiting with interest to see how the UK legislator will clarify whether a cross-border merger having a third country company would be still permitted from the perspective of the UK law. From the perspective of opening a branch in Luxembourg, again, the legislation in Luxembourg is very welcoming. Even if the freedom to establish will no longer be automatic, as we said, due to the loss of the status of member of the UK. However, so it will be still possible to open a branch in Luxembourg. The prerequisite should be that the mother company should have a legal form which is comparable to the types of companies which are recognized in Luxembourg. However, the opening of the branch and further the disclosure of information that would need to be achieved will be extended, as of course UK will be treated as a third country as opposed to the EU. So there will be a certain extended set of obligations and of information to submit upon incorporation and further on to be kept. And a point of attention would be, of course, the accounting, filing and reporting that will need to be done for the branch in order to achieve the same standard imposed by EU law and by Luxembourg law. With a point of attention on the fact that at times there might be the cases where audit obligations might also apply. From an accounting and reporting and filing perspective, obviously the UK will choose to use the UK adopted IAS for the financial years which will elapse as of 1st of January 2021. These standards, if we are comparing the UK standards with the EU standards, they are currently the same. However, due to the fact that we will have no harmonization, this might change depending on the change of legislation and of further standards to apply. The UK subsidiaries which have a parent in the EU, they will be no longer eligible to apply the exemptions that were available in preparing and filing accounts. As discussed previously for the branch, at any time a UK company will decide to open a branch in the European Union, they will need to check the local accounting reporting requirements to see if these are equivalent or that there are some further formalities that need to be performed. From a Luxembourg law perspective, there might be certain exemptions still available for companies incorporated in the UK to the extent the rules applicable when preparing the accounts and the statements are equivalent to the ones which are available in Luxembourg, and those statements will be audited in accordance with the UK law. At the moment, we can construe that this is possible, and the regime is still favorable to the UK as the standards remain very similar. However, this obligation will need to be checked in the future, depending on the future amendments brought to the legislation in the UK. A very important point of attention, usually in all the contracts, is the governing law and the choice of jurisdiction clauses. From a choice of jurisdiction, from a choice of law perspective, Rome I regulation, which was the one governing the choice of law for contractual obligations throughout the EU, was included in the national law of the United Kingdom. So in this case, the choice of English law will still be applied by all the other EU member states, and the English courts will continue to apply the choice of law of the parties, even if this means that they will be eventually applying the EU law of another EU member state. The situation is a bit more complicated when we are talking about choice of courts, jurisdiction, and enforcement judgments. As initially there was the Brussels regulation that applied throughout the EU. For the time being, the UK has applied to join the Lugano Convention, which is an equivalent regime to apply to the Brussels regulation. However, the Lugano Convention is not formally enforced in the UK, and the approval process is still pending. So for the time being, the UK is trying to use the provision of the Hague Convention, which arguably seems to be enforced in the UK, which provides that exclusive clauses of court agreements must be respected. The Hague Convention is still a subject which is under discussion at the moment between the EU and the UK, due to the fact that the EU adhered to the Hague Convention several years ago. However, it adhered in block for all the EU member states, and the UK is trying to use this previous adherence of the EU as a passport for it to use the Hague Convention, while the EU it's arguing that the UK, in order to benefit from the Hague Convention, would need to ratify and adhere in its own right to this legal instrument. From an arbitration perspective, Brexit will not affect the jurisdiction of arbitral tribunals or the enforcement of the awards, because both the UK and the EU member states are parties to the New York Arbitration Convention, and from this perspective, the convention provides that the signatories will recognize and enforce arbitral awards made by any tribunals which are sitting in the jurisdictions of the states that adhered to the convention. From this perspective, due to the fact that Brexit applied in its own right to the New York Convention back in the day, the New York Convention remains fully applicable between EU member states and the UK. Thus, the arbitral awards made by tribunals which are sitting in the UK will continue to be enforceable in the EU member states. However, we are expecting to see an increase in the tendency to apply for arbitration clauses in the agreements due to the lack of clarity which is applicable to the jurisdiction clauses, the normal jurisdiction clauses as explained just before. From an insolvency law perspective, the automatic recognition of insolvency procedures, which were available before under the insolvency regulation, will obviously no longer apply. The recognition of insolvency procedures which commenced in the UK as of 1st of January 2021 will again need to be assessed by on a case-by-case basis, and we will need to check again the national law of each jurisdiction to see which would be the legal treatment for a certain circumstance. From a Luxembourg law perspective, the Luxembourg courts accept the principles of unity and the universality of bankruptcies, which means that the courts of jurisdiction of the principal establishment of the debtor will remain competent to open insolvency proceedings and to rule on insolvency-related matters. So, in principle, opening of insolvency procedures regarding a Luxembourg entity will be recognized in Luxembourg. However, there might be additional safeguards and enforcement procedures in place, such as the exequatur recognition procedure, which will include also a check performed by the Luxembourg courts in relation to the insolvency proceedings which were not performed in Luxembourg or in the EU for that extent. I think that for the moment that would be it from a corporate law perspective. The conclusion is at the moment that a wait-and-see approach would still apply in relation to corporate law matters. We are seeing indeed the fact that Luxembourg legislation is very friendly. It does not provide further restrictions or very big differences of treatment between the EU members and the non-EU members. However, clarification on various points, as discussed, will need to be transmitted and to be enacted by the UK legislator in order to ensure the same level of efficiency of mechanisms which were previously very well used in practice at the level of the EU. So thank you very much.
Thank you, Nastasia. Again, another very interesting presentation, and also very interesting, I think, for those of us with groups that have EU and UK companies in their structures. So that's great. Then moving on, we have Vincent Wellens from United Util. He's the partner and head of United Util's Intellectual Property and Technology Law Practice Group. He represents major international, national and public sector clients on IT and digital transformation projects, as well as on high-end privacy matters, and also in a contentious context. He's practiced IP, technology and competition law at other first-tier Luxembourg and Brussels law firms, and gained in-house experience as well as an EU TMT regulatory counsel at Post-Luxembourg. So as an author of numerous publications and a frequent speaker at conferences and all of that, I think he's going to be another great speaker to have today. So over to you, Vincent. Basil.
Thank you. Thank you for the invitation. So I'm last to talk about a interesting topic. I think you have been slapped around with GDPR. So that's another presentation, and more specifically in the Brexit and COVID context. So two different topics, but very relevant. First of all, about data protection in a Brexit context. It could have been a bit more exciting, but as it seems now, there will be an adequacy decision for the United Kingdom, which means normally international data transfers, so that means transfers of personal data outside the EU or the EEA are prohibited unless the country concerned is covered by what we call an adequacy decision of the European Commission. That means that the European Commission will audit actually the legislation and the practices in the country at hand, and will say then, well, actually that country has an adequate level of protection, and I will put it on a white list. So Japan is on that list, Argentina, Israel, the UK. So that is going in the good direction, and that process should be closed according to the withdrawal agreement. That should be closed before the 30th of June of this year. Until then, the UK still benefits from equivalence in terms of data protection, so you don't have to put in place anything particular. But of course, if the UK does not manage the date of 30 June 2021 to be on the adequacy list, you should then look at some alternatives. But we are quite confident that will go in the right direction. Also important to mention, it's not a topic of today, but the US have a kind of self-certification mechanism which is called Privacy Shield, which also benefited from an adequacy decision, but that adequacy decision was overruled in the famous Schrems II decision of the Court of Justice of last summer, because the US authorities deploy a bit too much mass surveillance measures, and for that reason the Privacy Shield was withdrawn. Now, this being said, the fact that there is mass surveillance in a particular country could also lead to the withdrawal of other adequacy decisions. So imagine that the UK may take a total different stance on data protection and weaken the GDPR level it's used to now. That could jeopardize actually the adequacy decision of the UK. But that's not that's out of the question for the time being. Now, a lot of people think, well, the United Kingdom will be on that famous white list, so of countries that have an adequate level of data protection. So I'm cool. I don't have to do anything anymore. That's of course incorrect. So data that are transferred to the UK and that fall under EU competence still must follow all other provisions of the GDPR. So, for example, if I'm a fintech in Luxembourg and I have my back office in the UK, and the back office processes a lot of personal data on behalf of the Luxembourg-based fintech, then there is a data transfer, and that must be taken into account in a lot of other things. For example, as you know, in terms of information toward the data subject, you have to give a privacy notice. That privacy notice should explicitly mention that actually data controller, for example, or fintech in the payment space, will transfer data outside of the EU EEA and must then also indicate on which instrument that transfer relies, for example, on the adequacy decision. Another very important point that is very often forgotten is that UK-based data controllers, which fall under the GDPR, also must appoint a representative in the European Union. So this is also the case for US-based data controllers or data controllers in other non-EU EEA countries. They have to appoint an EU representative even when the country concerned is on that so-called whitelist. I think that are the most important takeaways. So you still have to update your documentation. So the privacy notice, pay attention. For example, in the fund space, the privacy notice is very often to be found in a subscription agreement for investors. Of course, then you must update that document as well. So that's what Brexit is concerned. Of course, the fact that it enjoys an adequacy decision makes, of course, the things a bit more simpler and also less fun from a legal perspective. But I think it's a very good solution that there will be an adequacy decision for the UK. Then data protection in a COVID-19 context. Christophe already touched upon some issues from an employment perspective. Of course, that is also on the intersection with data protection. There we can identify a few topics. So first of all, given we are talking about personal data in a COVID-19 related context, we are talking about health data. So also vaccination data. So the data, whether you had a vaccination or not, or whether you tested negative or not, these are also health data. And there is a principal prohibition for employers to process health data. That makes it very difficult unless the employee has consented to the processing. Now, processing must be also free. So, and normally, traditionally speaking, consent is not considered to be a good option in an employment context because a consent given in an employment context is often considered not to be free. However, there are some new business models where, for example, third-party service providers, they offer screening tests on the work floor of some bigger employers. And towards these third-party service providers, a valid consent could be given. The third-party service providers will do, for example, some screening. They have been mandated by the employer, but the employer will never see the individual data, and then the third-party service provider will be actually the controller of these health-related data, and the employee can, in principle, give a valid consent towards such a service provider. Another exception where employers or where health data can be processed in an employment context is where the employer has a legal obligation. For example, and that's a nice one, actually, the employer has the obligation to assure a healthy and safe workplace. That's, of course, a very broad obligation, and the first reflex of many employers was as well, we can do whatever what is necessary to keep our workplace healthy and safe. Now, the CNPD has already indicated, so the CNPD, that's the Luxembourg Data Protection Authority, as you probably know, has already indicated that it has a very restrictive view on what an employer can do to assure a healthy and safe workplace. Because on the opposite, you could even say that you could even require from employees to subject a negative test to come back to work. Wouldn't that be a measure that would serve the objective to assure a healthy and safe workplace? I think there is something to say about it, but the CNPD doesn't see it that way. Now, besides the general obligation to assure a healthy and safe workplace, you also have COVID-19 specific obligations for employers. So employers can receive, because employees have to give a medical certificate for family leave reasons in the COVID context, and employees also have to inform the employer about quarantine or isolation measures they may be subject to. So there are some legal provisions that allow that data flow, that health data flow from employee to employer in the COVID-19 context. Especially in the beginning of the crisis, we had a lot of these questions about what if we measure just the temperature at the entry of the premises? Is that allowed? So there was a little back and forth between data protection authorities, but just measuring the temperature without recording anything is considered to be not considered to be a processing of personal data. So that is also very welcome. But the CNPD also notes that measuring a temperature may not be an adequate measure to detect or to screen COVID-19. So a second point is also, we all have been subject to that, to home working. So a lot of employers had to deploy very rapidly strategy in terms of home working. Who says home working says also security measures. As an employer, you're a data controller not only over your employee data, but potentially also over client and customer data and other types of personal data. There is an obligation to keep these data secure. So that means if you allow employees to work from home, you also, as an employer, should make sure that you have the necessary security measures in place. We also have seen that when deploying a home working strategy, that a lot of employers also began to increase the monitoring of their employees, because of course, a lot of programs, if you work on Teams or on other collaborative and video conf means, you can also see when somebody is there in the office or not. And some of these measures that you can see whether somebody is there or not can be considered to be the monitoring of employees, and that triggers also an increased obligation of information towards the employees and the staff delegation. And very often it's also forgotten that in a home working context, you will often deploy technological means which are potentially privacy intrusive. So you should consider in most cases whether to carry out what we call a data protection impact assessment to measure the risk and also to take some risk-reducing measures. Last point, in the COVID context, you heard also about tracing apps deployed by governments. That has not been implemented in Luxembourg, most probably also because of the privacy sensitiveness of this topic. But in other countries and on EU level, data protection authorities have already given their views on the deployment of tracing apps by governments, that these should be as voluntary as possible, that data should minimize. So if the data are not necessary anymore, you shouldn't store them for a longer period in time, and unnecessary data should be deleted. So that's actually in a nutshell what is interesting to mention from a data protection perspective in relation to Brexit and COVID. Of course, if you have some questions and you want to deepen some points, you're most welcome to contact us.
Thank you, Vincent. Again, lots of food for thought there for companies. So it's been a great and very interesting webinar. I see that we have a couple of questions come in. I'm going to limit the time maybe to between 5 and 10 minutes just to try and quickly get through the couple of questions that have come. But I don't want to delay people too much longer than that on the webinar. So just on the first, I see two different questions that have both come in that are relating to employment law aspects. One, and they're kind of interlinked. So Christoph, I'm going to direct them towards you. But the first question is, what about a role which requires international travel, as it seems increasingly likely that only people who have vaccination certificates will be able to fly? So can an employer exclude someone who does not wish to have the vaccine? And linked to that, we also have, can an employee refuse to go on a business trip to a country with low vaccination rates? So I can repeat again if needed.
Thank you, Darina. I think I got the questions. So on the last question, if an employee can refuse to go on a business trip if they believe that the vaccination rates are too low or the COVID-19 cases are too high in a country, there one clearly has to look at governmental recommendations. If a country is marked as a country where you should not travel, then an employee can refuse to travel to that country, because employees under Luxembourg labor law do have the right to withdraw, so to not perform their work, but that's only possible if there is an imminent and serious risk to their health and safety. And if a government says that, well, it's not safe to travel to one place, then it would also probably be possible for an employee to refuse such travel. To the first question that came in via the chat, well, first of all, I'm not sure if international travel will be limited to people who took the vaccination, because the European Commission actually is currently discussing the implementation of a vaccination passport, and governments made relatively clear that this will not prevent people who do not take the vaccination from traveling, because that would be a clear discrimination against people who cannot take the vaccination due to medical conditions or religious philosophical beliefs, but also against people who simply don't want to take that because it is their individual right. So as long as there is no general public obligation to get vaccinated, I doubt that travel companies can restrict travel to people who got the vaccination. But if there were such a general obligation, and an employee would nevertheless refuse to take or an employee who has to frequently travel on business, and such employee would refuse to get vaccinated, then that might be a reason for dismissal. Now, if an employer decides to exclude someone from business travel because they think it's not safe, well, the employer always has the right to exclude the employee. However, that has to be on full pay and on full benefits.
Okay, thank you, Christoph. I think that really answers those questions. There's also one linked to the vaccinations for Vincent on data protection. Vincent, I don't know if you're there. Can an employer ask its employees about their vaccination status?
Yeah. No. So as Christoph also correctly indicated in the beginning, vaccination, as it seems, will not be compulsory. So then it's also not allowed for the employer to fish about the vaccination status or not. So, and on top of that, the vaccination status is also health-related personal data. So then you also fall in the category that you either must have the consent, which is not likely in an employment context, or on that you have to base yourself on the legal obligation to assure a healthy and safe workplace. I personally think it would make sense to if you have a very human resource centric business, for example, in an industry, I don't know, fabric of Goodyear or something, that it could make sense, but it's most probably not allowed by the CMPD, which is showing not so flexible. And we have the problem also for some higher education institutions who also do not have the possibility. They don't have any legal basis to process health-related data of students, for example, and which is quite problematic if you want to open again your classes.
Yeah, no, understood. I also have a question here for Mark. Mark, someone is wondering, why would they need to establish an entity in Luxembourg if they can provide services on a cross-border basis?
Well, it depends who they're trying to access. So, first of all, I guess there are 2 points. One is, obviously, it's all well and good having a right of access into Luxembourg, but that is limited in terms of client type and geographic reach. So you don't have an onward passporting right. So if you want to provide any additional services elsewhere within the EU, you will either you'll need a base at some point or some sort of structuring solution. So at that point, obviously, one of your options might be to establish an entity within Luxembourg, which then itself has an onward passporting right. The other is you have to be careful where you're accessing retail investors. So the current cross-border distribution right, or the fund, the sort of investment services service right, is only to per se professional clients and eligible counterparties. So if you have a sort of regular de facto professional client or a retail client, then you do still have to have a local presence. So, for example, for fund distribution, this is a classic example where you might need to be careful.
Great, thank you. Yes. And lastly, Anastasia, I have a question myself for you. Just wondering what practical advice you might have to mitigate potential discussions on choice of jurisdiction clauses when opting for UK law as the applicable law.
Yeah, so here situation obviously it's a bit complicated for agreements which have been already concluded. Going forward, we might take into account one opting for arbitration, but indeed here we need to factor in the costs and whether the parties are willing to pay those costs and maybe to set forth complicated procedures in the agreement. So there's the arbitration, which is obviously providing for a more clear context. If we are to discuss about choice of jurisdiction clauses, in order to make sure that the Hague Convention applies, we recommend to have clear contractual provisions saying that setting forth an exclusive choice of jurisdiction. And obviously for the contracts which have been already concluded, perhaps to the extent it's achievable by the parties, enter into an addendum clarifying this, that we have an exclusive jurisdiction clause applicable, in order to make sure that the Hague Convention will apply and will be the level playing field for to treat that matter into dispute.
Great, thank you. Good to keep that in mind. Okay, I think we can close off the questions with that. I would just like to say a very heartfelt thank you to all of our speakers today. I know you've all put in time and effort in preparing for this webinar, and it really was really interesting, and I hope our attendees enjoyed it and found it as informative as I did myself. Just one other little point, just more on an administrative aspect. Please feel free to keep an eye on our website at the bcc.lu to see any upcoming events. We have one coming up on the 29th of April. Our Business and Innovation Group are running a webinar focused on academia and business innovation in Luxembourg. So please do keep an eye on that. And again, thank you to all the speakers. Thank you to the team in the BCC, particularly Becca and Wei, for assisting us all with the IT aspects of all of this and coordinating things as well. I think we can close the webinar, and again, bye-bye and good evening.
Thank you.